Welcome back to the Deep Dive. Today, we were staring down a fascinating and I think really high stakes intersection of psychology, the workplace, and of course the courtroom.
It's a tricky one.
It is. We're looking at a case that forces us to ask a really fundamental question about responsibility and expertise. Specifically, when someone operates a machine, in this case, a polygraph, do they owe you the same basic duty of care as, say, a driver on the road?
Just, try not to cause harm.
Exactly. Or is it a specialized higher duty of care, something more like a brain surgeon or a corporate attorney?
And it sounds like a subtle legal distinction, but the consequences are massive. We're essentially asking, is a lie detector test just a routine mechanical process, or is it a professional, almost medical-grade procedure?
Because the answer changes everything.
It does, because if things go wrong, the label we slap on that operator determines whether you even have a case or not.
Right. And to answer that, we have a stack of sources centering on the case Lewis v. Rodriguez. Our mission in this deep dive is to figure out exactly where the law draws the line between an ordinary worker and a professional.
Exactly. And the path we're going to take is pretty structured. First, we need to define the legal criteria for what professional status even means. We'll see the court borrowing frameworks from labor law to apply to tort law.
That's interesting.
It is. Then second, we'll dissect Lewis v. Rodriguez to see how the court applied those specific factors to a polygraph examiner. And finally, we have to look at a crucial procedural hurdle, a real gotcha moment, really, about jury instructions and preserving an error for appeal.
Let's jump straight into the doctrine then. Before we get to the specific story of Mr. Lewis, we need to understand the playing field. In the source material, we see two theories of liability battling it out: simple negligence versus malpractice. What is the actual practical difference between these two?
Well, it all comes down to the standard of care. The general rule comes from a case called Garcia v. Collar-Tile. For simple negligence, the standard is that of a reasonable man.
The average person.
The average person, exactly. If you're walking down the street, driving a car, you just have to act as a reasonable person would to avoid harming others. You don't need a special degree to know not to run a red light.
And malpractice, how does that change things?
Malpractice is different. It applies to someone rendering services that result from, acquired learning or special training. The standard here isn't the average person on the street. It's what a reasonably prudent person skilled in such work would do.
So it raises the bar.
Significantly. You aren't judged by what a layperson would do. You're judged by what a competent professional in your specific field would do.
Okay, so enter our test case, Lewis v. Rodriguez. This is the case that had to decide which of those two buckets a polygraph examiner falls into. Let's analyze it. First, let me lay out the legally dispositive facts here. The plaintiff, Herbert C. Lewis, was a corrections officer. He found himself at a terrible spot. Informants inside the jail accused him of smuggling drugs to inmates.
A career-ending accusation.
Absolutely. So his employer required him to take a polygraph examination to keep his job. The defendant, Abe Rodriguez, was the man hired to administer that test. Now here's where it goes completely off the rails. Lewis testified that just before the exam, Rodriguez became obnoxious, belligerent. He started yelling at Lewis, even using obscenities. So Lewis naturally became angry and upset. Rodriguez then just proceeded with the test, interpreted the data, and scored the test as deceptive. Based on those results, Lewis was fired. He sued, but the twist is that the trial court instructed the jury on malpractice, not simple negligence.
That is a perfect summary. The key there is the behavior of the examiner and then the judge's instruction, a huge moment in the case.
Which brings us to the core legal issue. What was this specific question the appellate court had to answer about that jury instruction?
The issue was whether the trial court messed up by instructing the jury under a malpractice theory. But, implicitly, the court had to answer a totally new question. Is a polygraph examiner a professional under the law?
If they are, the instruction was okay. If not.
If not, it was a reversible error. The whole verdict gets tossed.
And since this was a new question in tort law, what rule of law did the court apply to figure out what a professional is? Can you state the full rule and break it down into its testable elements?
Sure. Since there wasn't a direct tort case on this, the court got creative. It looked to the National Labor Relations Act and the Fair Labor Standards Act for guidance.
From labor law.
Exactly. And from those statutes, they pulled out a four-part test. The elements are: first, the work must be predominantly intellectual and non-routine.
Okay.
Second, the work must involve the consistent exercise of discretion and judgment. It can't be something standardized by a stopwatch.
Right.
Third, the work requires knowledge that is customarily acquired by specialized study. And fourth, this one's more of a persuasive factor, but it's the existence of a state licensure requirement.
Thank you. That gives us a really clear roadmap. So now for the court's elemental analysis, let's walk through this step by step. How did the court apply that first element, intellectual and non-routine work?
Well, the court looked at what a polygrapher actually does all day. Rodriguez's argument was basically, I'm just a technician running a machine, but the court found that each case is completely unique.
How so?
The examiner has to research the specific facts of the allegation before the person even walks in the door. They have to interview that specific person to understand their psychological state. It's not mechanical at all. The output can't be standardized because every single human subject is different.
I see.
So the court concluded the work is predominantly intellectual and varied. First element, met.
Understood. It's not an assembly line where you just tighten the same bolt over and over. Now, what about that second element, the exercise of discretion and judgment?
This one is maybe the most critical element. It's what really separates a technician from a professional. The court looked at the specific steps Rodriguez took, and they found discretion is required at every single stage.
At every stage?
Every stage. First, the examiner has to decide if the issue is even testable. Then they have to assess the examinee's suitability. Are they too emotional, too tired to get a clean reading? Then, and this is huge, they have to formulate specific questions.
They don't just read from a script.
No, they create relevant questions about the incident and control questions designed to get a baseline reaction, all tailored to that person. And then finally, they have to interpret and score the squiggly lines on the chart. That interpretation requires a ton of judgment. So the court found the role requires consistent exercise of discretion.
It sounds like there's a lot of subjective analysis there,
Yeah.
especially in formulating questions and then reading the charts. Okay, what about the third element, specialized study?
This one was a bit of a closer call. The court did note that polygraphy school isn't prolonged like, medical school. It's usually about 3 months of intensive training.
Which doesn't sound like a lot.
It doesn't, but the court found it still counts as specialized schooling. And it's not just the school, it also requires internships under supervision and ongoing continuing education seminars to keep up with the field. So the court reasoned this is knowledge customarily acquired by specialized study, which is different from just an apprenticeship where you watch someone else work.
Okay, so that element was also met. And finally, the fourth element, licensure. How did that play into the court's reasoning?
This was a really strong point for Lewis. The state of New Mexico actually defines polygraphy in its statutes. And crucially, the state requires a license to practice it. To get that license, you have to pass an exam.
So the state itself treats it like a profession.
That's exactly how the court saw it. They viewed this legislative requirement as strong evidence that the state sees this role as a profession that affects the public welfare and needs to be regulated.
And after analyzing all the elements, the intellectual work, the discretion, the specialized study, and the licensure, what was the court's final conclusion?
The court held that yes, polygraphers are professionals. Therefore, they are subject to a malpractice standard of care, not simple negligence.
And what does that mean for a trial?
It means that because their procedures and how they interpret the charts are not common knowledge to an average juror, you need expert testimony to prove they were negligent. So the trial court's decision to give the malpractice jury instruction was correct.
Okay, I want to pause here. We've gone through the legal checklist, and it makes sense on paper. But for the listener, and honestly for me, I want to really nail down why this distinction matters so much in the real world. Why does it matter if we call Rodriguez a technician or a professional? Can you give us a more visceral hypothetical to illustrate the difference?
Absolutely. Let's think of it as the difference between an angry doctor and a rude cashier. And this analogy comes straight from the facts of this case, with Rodriguez yelling.
Okay, lay it out for us.
Imagine you go to a grocery store. The cashier is having a bad day. He's rude, he yells at you, maybe uses a curse word while scanning your milk. It's unpleasant, right?
Very.
But does his yelling change the price of the milk? Does it alter the actual transaction? No. You still get your milk, the receipt is accurate. His job performance, the technical part, wasn't really broken by his bad mood.
Right. He's just a jerk, but the machine still works.
Exactly. Now let's switch to a professional context. You're in a hospital bed, or in this case, a polygraph chair. You're hooked up to sensors measuring your heart rate, your blood pressure, your sweat. If a doctor or a polygrapher starts screaming at you right before taking a measurement, what happens to your body?
My heart rate would spike. I'd start sweating. I'd be agitated. My blood pressure would go through the roof.
Precisely. The rudeness here doesn't just hurt your feelings, it scientifically alters the data. The anger spikes the chart. Because a professional holds specialized knowledge of how emotion affects the instrument, their behavior actually corrupts the result.
I see.
Rodriguez knew, or he should have known as a professional, that yelling would ruin the test's validity. That is why it's malpractice, not just being a jerk. The professional standard requires them to know that their conduct directly impacts the diagnosis.
That clicks. That really clicks. The professional standard holds them accountable for the scientific impact of their behavior, not just the social impact. Okay, let's pivot. We've established Rodriguez is a professional. He lost that argument. But the appeal didn't stop there. There was a second, more procedural argument about how the instruction was given. This moves us to the locality rule.
Right. This is a secondary, but a really vital procedural analysis.
So let's analyze this procedural appeal. What was the core legal issue here?
The issue is whether the trial court erred by failing to instruct the jury on the locality rule. Basically, Rodriguez argued that the jury should have been told that he's only bound to the standard of care of other polygraphers in that specific locality, so New Mexico, rather than some national standard.
That seems like a valid point to at least raise. But before we get to the merit of the rule, we have to talk about how you even get to argue it. What is the black letter rule for appealing a jury instruction? This is about the preservation of error.
The rule is strict. It's really a trap for the unwary. To appeal a jury instruction, a lawyer has to do one of two things at the trial. Either you tender, that means submit a correct written instruction to the judge, or you have to specifically object to the error in the instruction that was given.
And you have to do it then and there.
Before the jury leaves the room. You can't just wait to see if you lose and then complain about it later.
So let's look at the analysis. What did Rodriguez's lawyer actually do?
Well, that's the problem. He didn't do either of those things. The record showed that his attorney talked about the instructions with the judge. He objected to using a malpractice instruction at all because he wanted the simple negligence one. But, and this is the key, he never submitted his own written instruction that included the locality rule, and he never stood up and said, "Your Honor, if you are going to use this instruction, it's defective because it's missing the locality language."
So by being silent on that specific detail, what happened?
He waived the issue. He lost his chance to appeal it. The court explained that you have to alert the trial court to the specific defect so they have a chance to fix it right there. Since he failed to do that, the appellate court refused to even consider the argument.
And the final conclusion on that second issue?
Judgment affirmed. The verdict against Rodriguez stands.
It's a harsh lesson in courtroom procedure. You absolutely have to speak up or you lose your right forever. So we've covered the definition of a professional and the importance of preserving error. Now, for the listener who might be taking a law exam or just trying to organize this, let's synthesize this. Can you boil it all down into a diagnostic checklist?
Absolutely. If you're looking at a fact pattern with a worker causing harm, here's your framework. Step 1. Determine the standard of care. Don't just assume it's simple negligence. Check for those professional indicators. Ask yourself, is the work intellectual and non-routine?
Not just tightening the same bolt.
Right. Then ask, does it involve consistent discretion, like creating questions versus just reading them? And then, is there specialized training? And crucially, is there state licensure? If the answer to these is yes, you apply the malpractice standard. You measure them against a reasonably prudent professional, and you will likely need an expert witness.
And if the answer is no?
If the answer is no, you apply simple negligence, the good old reasonable man standard.
Okay, that's step 1. What's step 2?
Step 2, check for procedural preservation. This is key. If the case involves a bad jury instruction, look at the trial facts. Ask, did the losing party object on the record to that specific error, or did they submit their own correct version? If the answer is no, the issue is waived. The appeal on that point is dead on arrival.
That is a powerful toolkit for analyzing these liability cases. It really highlights that being a professional isn't just about a fancy title or a degree. It's about the complexity of the judgment calls you have to make and the trust the public and the state places in you.
Precisely. And in the case of the polygraph, that trust is huge because the output of that machine can literally change someone's life. It cost Mr. Lewis his job.
Well, that brings us to the end of this deep dive into Lewis v. Rodriguez. It's a great reminder that whether you are a doctor, a lawyer, or a lie detector administrator, with great discretion comes great legal responsibility.
And it seems a duty to keep your cool.
Exactly. Thanks for listening, and we will see you on the next deep dive.